The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. Not only is this program heard in Des Moines, but it's also heard in Council Bluffs every other Thursday. We run this program on Mediacom Channel 15 here in Des Moines, Sunday afternoon at 1 o'clock and Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My number here in Des Moines is 515-276-3956. John's number is 515-282-2672. Those numbers are for any parent that would like to give us a call, and we try to help on a one-to-one basis because we're concerned about the families out there that are losing their children to the DHS. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. That stands for Child Protection in Iowa. Two major areas that we focus attention on are influencing public policy as it relates to child protection issues. And secondly, as Don mentioned just a moment ago, we like to work with parents who are having difficulties with the Department of Human Services and the juvenile court. That is not legal representation. It's not illegal, I shouldn't say it that way, but we are not attorneys. We're not equipped to practice before the bar, nor are we licensed to practice before the bar. If you're in need of legal assistance, you need to hire somebody who is sanctioned to operate under those licensing conditions. Well, we do find, however, that quite often parents who are willing to look at the statutes, who are willing to do discovery, and Don can show you how to put a package of discovery together pretty quickly. If you're willing to do that kind of thing, you can do a lot of the legwork yourself, and you can probably do as good a job as many attorneys might be able to do in court. And by the way, you have an overriding concern about the outcome of your case. So you have a reason to do a good job, whereas an attorney might have money on his mind as a direct result of him doing a good job. That's not to say that a servant is not worthy his hire, but it simply says that you probably have a good motivation for doing the job and doing it right. We might be able to give you some hints along that line. And there is nothing that keeps you from arguing your case in court yourself, unless you decide to take a court-appointed attorney. Once you accept a court-appointed attorney, you pretty much tie up your hands and leave everything to the attorney to do. Some individuals find it difficult to accept what the court-appointed attorneys do for you or on your behalf, or fail to do for you on your behalf. But that's too late now, because the attorney's already been appointed, and whatever the juvenile court wants to do to you now, they're free to do that, because they quite often have the confidence that they can get by with anything so long as they have that court-appointed attorney. And by the way, that court-appointed attorney may not get the next appointment if he fails or she fails to follow what the DHS and the court want that person to do. So they have a motive to do it, not to do it right, or within the law or within your perspective of what needs to be done for your family, their motivation is to do it what the court wants, because it is the court that is paying the bill or authorizing the payment of the bill for the court-appointed attorney. Another thing about a court-appointed attorney is that you may find later on, after all is said and done, you've lost everything in court, they may come back to you and say, by the way, there are some court costs that you need to pick up, including the cost of your court-appointed attorney. Well, I thought a court-appointed attorney was supplied by the state without cost. That court-appointed attorney is supplied to you without cost at that time to make sure that the court gets its way with your case. And once that's done, then you may find yourself with the bill. So be very careful, very cautious in going into court with a court-appointed attorney. One rule is you never go into court with an attorney you can't trust. And how many people do you know who have gone in with attorneys that everybody knows they can't be trusted, but somehow circumstances prevail, or prevailing circumstances are such that you go in encumbered with an attorney who may not be doing the proper service, legal service for you. The more you can do for yourself, the better, particularly in juvenile court and in the administrative process with DHS. It has been shown that people who go into DHS administrative hearings do just as well with an attorney or without an attorney as those who go in with an attorney. What does that say to you? Think again before you take an attorney with you, and give up $5,000 or whatever it is that attorney wants to fight your case. There are some good attorneys out there. I can probably count them on my left hand. So be extremely careful. Get advice from other folks. Find out what that attorney has done for other folks. Find out what that attorney's track record is. Some of them will even tell you what their track record is. So, and it doesn't hurt to sit in the courtroom where that attorney is practicing. I've seen some pretty magnificent attorneys, and I'm really impressed with how they handle cases before the bar. Some of them can think on their feet. Some of them can't do a real good job of thinking at all. But I'm impressed with the ones who know how to handle a case in court and also know how to talk to their clients. This is a real struggle as you go looking around for an attorney. Let's turn for just a moment now to talking about the venue, that is the juvenile court. The juvenile court is not just like any other court. It's a little over 100 years old in its formation. It was designed for children under the age of 21. It was designed because we knew that for a child to be tried in an adult court could cause a lot of confusion and injustice. It was designed in such a fashion as to give deference to the needs of a child. It was designed solely around the principle called the best interest of the child. The best interest of the child wasn't really well defined until a fellow by the name of Dick Woods helped the Iowa State Legislature define what the best interest of the child was. the best interest of the child in Dick Woods's draft of the statute says that the best interest of the child is found by maximizing his contact, the child's contact, with both natural parents. And so that comes up in the divorce code. So that any time that there is a struggle with respect to the best interest of the child, we have to be concerned that the child has maximum access to both parents. That doesn't always happen. So the court is supposed to step in on behalf of the child to be sure that warring parents will not interrupt the best interest of the child. Well, there are other distinctions between the juvenile court and the district court, too. Much of what is done in the juvenile court is secret. Much of the record is secret. So one of the valuable things that our founding fathers determined about open court is not available in juvenile court. That is the right to public trials. Now, the most that they can do in district court in states where capital punishment is allowed is to take your life. The most that they can do to a person in juvenile court is to deny you your freedom. It's to throw you in prison. They can demolish your checking account. They can demolish everything that you own. They can put you into poverty. Then they can put you in jail. In juvenile court, they cannot incarcerate you. They cannot take your life. But listen to this. In juvenile court, they can take your children. And to some people, that is tantamount to life. To lose the precious interaction, what they call the consortium with children, is a right bestowed upon parents, but that right can be denied by the juvenile court in secret. No one needs to know about it. In fact, even when it comes on appeal, it comes with initials in the interest of KT or in the interest of MM. It doesn't come with the child's name attached to the appeal. So a lot of the things that we have and we hold dear as rights in district court are denied you in juvenile court. Juvenile court can tell parents that they have to go to parenting classes. They have to go to classes on how to budget their incomes. They have to go to classes on how to straighten up their homes and keep a household. They have to go to therapy classes, individual therapy and therapy for the family. They have to abide by all kinds of hoops in order to get visitation with their children or to earn the privilege of getting their children returned to their home. And quite often we have seen families where the struggles, where the duties assigned to them by the juvenile court, and quite often given over to the authority of the Department of Human Services, those struggles can be so intense that they can't keep their job. I know of one fellow who had a very good job for a long time with a railroad, and he was making very, very good money. And because of the fact that he was assigned to all kinds of therapy and this and that, his boss simply called him in and said, do you really want to work? You're going to have a much more consistent pattern of attendance than what you've had so far. We understand you're having problems, but we're trying to run a railroad. So instead of the good salary from a railroad, he had to get along on making sandwiches for Subway. Well, it's difficult to make the kind of money that you need to make in order to hire the legal staff and to give full attention to your job, to the counseling, and to your visitation and so forth in order to get reunification. The juvenile court, because of the fact that they have such enormous amount of power, has gone completely out of bounds. So we recognize some real problems with the juvenile court. And the juvenile court, particularly if they get a person on the bench who has no scruples whatsoever, who may pretend to love children and families, but whose actions show differently, then you have a real problem. We're going to turn to Terrance Walker, who has looked has taken an in-depth look at what some of the problems are in the district court. And of course, he recognizes some of the difficulties. And the way he recognizes the difficulties in juvenile court is he's been in juvenile court. And so he recognizes that juvenile court doesn't always abide by statute. They're supposed to be driven by statute, and they're supposed to be driven by the rules of civil procedure. They don't always follow the rule book. We're going to turn to this expert right now and see what he has in terms of the current trend, the current things that we're seeing in the district court and in the Court of Appeals in the Iowa Supreme Court. Terrance Walker.
All right, appreciate it, John. I guess we must be kind of annoying to public officials that don't want to act within the laws. I know it must be annoying for them to see us on the air like, whoop, here we are.
Not Terrance again.
Airing your dirty laundry.
Not Terrance
right
again.
There on the air. That's
right.
Good, that's good. But yeah, just I wanted to touch on a few things, not only as it pertains to the juvenile court system and the DHS, but on the courts in general, because I mean we keep hearing this thing, this recurrent theme in the media about the independent courts. The courts have to be independent. We've got to guard their independence. The whole measure in South Dakota where they tried to implement a check on the judiciary by having some form of citizen grand jury system. The Supreme Court, former Supreme Court Justice Sandra Day O'Connor went around talking about how that was a threat to the independent judiciary. Yet, the funny thing is that the judiciary in South Dakota, in their campaign against the measure, along with a lot of the legal firms or whatnot, had countless ties to not only the banking sectors, but the law firm sectors and the insurance sectors and the teachers union sectors. So as far as independence goes, it seems like they're very dependent on those sectors and have a great deal of influence by those sectors because they contributed tenfold the amount of money. But I just thought it was interesting. This past week I ran across something that was generated by a guy by the name of Lawrence Agee, as it pertains to the independent judiciary and the unwritten rules of civil procedure by the independent judiciary. And I've got a copy here. I think you got another one there, Don. I'll read from this. I thought this was kind of funny because everybody that's been to court and doesn't have an attorney, I'm sure you can relate to this. There's 5 rules on here. I'm sure we can add a bunch though. Number 1, the unwritten rule of civil procedure in an independent judiciary court for pro se litigants. That's people that's representing themselves. Number one, the use of summary judgment. In the U.S. court, summary judgment has replaced due process of law. Due process of law no longer exists. And due process of law, for those that's not schooled in the legal profession, is just basically a concept that says that you get a hearing and you get an opportunity to present your case. And in this unwritten rule, any judge can dismiss any case at any time whenever the opposing party files a motion for summary judgment. This tactic is used whenever a pro se goes up against a lawyer, especially a lawyer who is well connected or friends with the judge. A judge would rather clear his docket, which means less work, than allow a case to go to trial, which is going to be more work. I think that's pretty fun. I think you can relate to that experience, can't you?
Right.
I remember a case in front of Lippman down here in Polk County. And there was a 3 or 4 cases all come together on the same hour, basically. And of course, he couldn't do everything all at the same time, and so he stopped the proceedings. And the second 2 cases, he just wiped off the books right there, so he wouldn't have to worry about them. One was a teen going to school, and he was more concerned that the teen go to school. So he instead of being in court the next day, because he would have to push the schedule to the next day to hear the case, and so he just wiped it off the books, so allegedly the kid could go to school. And after the proceedings were all over, I heard the county attorney, if you can believe county attorneys, she said to the judge, "I don't know why you did that, Judge. We've been trying and trying to get him up here in court here because of his problems. And what do? You just throw him out." Well, he probably didn't even go to school either the next day. He just probably was rejoicing. And so that's what they do with a lot of kids. Kids think, we don't have nothing to lose. We won't get thrown in jail or nothing. We'll continue to what we'll be doing. I've heard teenagers tell me that. Terrance?
Yeah. I've got a couple cases that I filed. I remember in federal court where, arguable issues, but since I'm going up against big government, and the big government attorney can say any or do anything they want, seems like with impunity, no matter how fraudulent or false it is, the judge just relies on the written argument of the state's attorney and says, summary motion judgment granted. And, they just say, well, Your Honor, this and this and this and this fact, and, they might be wrong, but, again, they still argue it. And they say, well, since there's no issue that's in conflict with there's no justifiable issue to have this matter to trial, we want summary judgment granted. And then the judge just goes ahead and issues the rubber stamp and grants the summary judgment. And then what makes matters worse is if they have several bases on which they argue for summary judgment, a lot of times in the judgment, you get the summary judgment order back, you don't know which basis they relied on. So then if you try to appeal to the next court, you're arguing all of the issues that they were arguing in the motion, and you're basically screwed because you're sitting there arguing stuff that you don't know what was decided on what basis. So, so you waste a lot of time. And this is one of the tactics, and this is one of the unwritten rules of civil procedures in the independent judiciary as it pertains to people that represent themselves in courts. Number 2, the right to appeal has also been abolished. If a pro se files an appeal in the federal court system, the case goes to one of the federal circuit courts. The federal judge or his clerk, a law student, looks at the bottom of the appeal, and if the words pro se appear, he issues the following opinion: denied. And I can say this happens sometimes in the state court as well. A lot of times in the state court. I don't think a lot of this stuff applies to the federal court. I can remember a lot of appeals where they basically were just denied on basis unknown, because a lot of times that's what they'll do, is if you have a good case and you're pro se, instead of dealing with the issues that you bring up, a lot of times they'll just say denied, summary judgment granted against the party, and guess who has to pay the costs? The person that filed the
Right.
appeal.
Right.
So,
I agree with you, Terrance. But I had an experience in front of a judge on where I issued a subpoena because the party said they would always accept a subpoena, even though I knew the law was against me on it. But I decided, under the circumstances, I'll go ahead and do it. Well, the county attorney, as soon as it came across his desk, he set up a hearing to quash the subpoena, and so we have a hearing on it. And I knew my end result was that I'd lose on it. We went in front of the judge, and I just told the judge what happened, how they denied me the first request without a subpoena, on an open records request, and then they told me to issue a subpoena. So I just told him that I served a subpoena on him, just like he asked, and so the judge said, "Okay, let me think about it," and he sent out a ruling, and he put down all the steps, and he said it was illegal. He said Don didn't have a right to the discovery through the subpoena because Iowa code does not allow for it. It's very strange why that is, but that's a fact of life. It's not in the Iowa code to allow for it, even though now under some circumstances, other circumstances allow for the subpoena.
was that another unwritten rule?
No, it's written. It's written.
Oh, so he was immune from subpoena.
Correct. Let's say the criminal Iowa code starts out with number 1, number 2, number 3. Well, down in the lower numbers, it's denied us. But then we get up closer to where you could be sentenced to death or some other reason, then subpoena is allowed. Well, anyway, his ruling came out, and he wrote everything down. He wrote the truth. Don didn't have a right to it. And then the final paragraph, conclusion, he ordered that I get the paperwork. You see, the judge has the power to do whatever he wants to. Whatever, it doesn't, even if it's contrary to the law. And in that case, I appreciated what the judge did. He did something that was right, so I could have my proper right to discovery, even though it was contrary to the Iowa code. If that makes sense to anybody, at least I got a favorable deal out of it. But that's just totally contrary to what you were talking about. I understand, Terrance.
Yeah, he's just totally refute my unwritten rules of I see how you're gonna do me here. Of course, there's examples to all of these. I've had a couple success stories. John has a couple success stories, or with just one. Just one.
That's all. I only get one, Terrance.
Don has a couple success. Well, I thought you just had that one, or did you have a couple?
No,
Success stories on the appeals.
The appeal, one success story.
One success
I've only
story.
been I've only been criminally charged and found guilty once.
Okay, but it was reversed
It was reversed, and that
on appeal.
that was only because this judge took it upon himself to do right. And had that judge not done that, it would be a completely different story right now. I wouldn't be in federal court because it'd be difficult to go to federal court to challenge something where you've been found guilty. So,
But why did you go into federal court if you were found innocent?
because federal court provided a means by which I could challenge the civil rights violations that came across.
On what they did wrong to you.
The due process. Okay.
Yeah. And then, okay, that brings us to the unwritten rule of civil procedure for pro se litigants in the independent court. Number 3, appeals to the Supreme Court. Pro se litigants who file cases with the Supreme Court basically waste a lot of time and kill a lot of trees. The Supreme Court
What
hears
did you
only
say, Terrance? Did you read that right?
yeah, basically, and kill a lot of trees. The Supreme Court hears only about 60 to 100 cases a year, considering the tens of thousands of appeals submitted. The odds of being heard are less than 1 in 100 for all lawyers. The only lawyers who get to argue before the Supreme Court are the famous lawyers, and the usual case to make it there is one where Circuit A disagrees with Circuit B, and where one and only one simple issue is to be decided, which is less work. And that is so true. And this is a sad fact because they were just talking on the news. I heard them last week. About 20 years ago, they were hearing twice as many cases. And here the Supreme Court nowadays, they only hear just a mere 60 or 70 maybe. And you get how many? 10,000 appeals to the, or writs of certiorari, they call them, to the Supreme Court.
United States
Supreme Court. And they do just whittle it down to one single issue. And the funny thing is, you can read those opinions. Opinions are kind of funny. They basically say, well, we're just going to decide this issue. We're going to leave it up to the other circuits to figure out the rest. So, in essence, they solve one problem, but then they create a plethora of other issues because they don't decide the case totally down the line and say, we're going to make this rule, this rule, this rule, this rule, this rule. They make one simple rule, and they leave the rest to be fractured again. So
is that to make big business for the attorneys again, to bring it back?
Yeah, I
up
think
to
that's
the court
part
system?
of the racket. I don't know. Someone needs to bring a RICO lawsuit against them for doing that stuff. I tell you, they need to make one set of rules to go by so that everybody's not, okay, well, how does this court handle this issue? Well, how does this other court over here? How's the Fifth Circuit? How's the Seventh Circuit? How's the Eighth Circuit handle it? Okay, well, when you have that many different circuits and everybody's still got a different opinion on the underlying issues, the one issue they did solve a lot of times is just they might as well not even have done it in the first place, because you're creating a whole set of new rules to the game and you're not defining them. So,
right.
But yeah, that's one other thing. Did you have any other comment on that, Don? Okay. All right. That gets us to number 4. Attempting to expose the corruption is futile. This is the unwritten rules of civil procedure. As the author has discovered, when a book is written to expose this fraud, there is no one who will publish the book. There is no place to publicize the book. The TV ignores the problem. The radio ignores the problem. The newspapers ignore the problem. No one really cares about the problem because it's not currently affecting them. And that is oh so true. Oh so sad. Thank God we have something like public access TV so we can be on every week and expose the corruption and just be an annoyance to the people that are trying to hide behind their black robes and their nice suits and try to sit up and act like everything is hunky-dory. It's not hunky-dory. We wouldn't be on here if it was hunky-dory. In the summary, I think we should add a few more. I don't know.
Oh, sure, by all means.
Did you have one or two to add, John, to the unwritten rules of civil procedure in court?
Yeah, but we'd be here all day, Terrance, so you better move on.
Just one or two. Just throw one out there, because I think this needs to be expounded upon, because I know there's a lot of unwritten rules of civil procedure.
Right off, I can't say one. I'm not.
One unwritten rule is give no slack to the jury in their deliberations. Write up their job description in something called instructions, and make sure. In fact, in one case, I think it was 102 pages of instructions that were given to the jury. And quite often I'll hear jurors say, well, that we read the instructions and we followed the instructions to the letter. Did you read the statutes? No. They wouldn't let us see the statutes. And they told us that we couldn't look up anything on our computers. We couldn't do any research on our own. We couldn't use our heads. And we certainly couldn't use our experiences. So basically, we were boxed in to the decision that the prosecutor wanted in the first place.
And we can't. We definitely was told to disregard that piece of paperwork that John handed us when we came into the courthouse.
Another unwritten
That's right.
rule would be if you have a case and you go to court and the assistant attorney general does not show up, the judge will either continue the case or get the judge on the phone and give him a second chance. But you won't find a pro se person getting a second chance. In fact, they'll even rule against you before the case even gets to court. But with an attorney, they'll give them a second chance for being late or lazy or whatever, but not the pro se.
No way. I ran into a situation like that where I wasn't the litigant in the case, but the attorney general, the assistant attorney general, was supposed to show up, and she had already written a motion to dismiss. So she, knowing that the judge always goes along with her anyhow, she figured the judge would go along and dismiss it, and she didn't need her presence there. Well, the litigant in this particular case complained and said, I want that litigant here. Well, the judge called her at her office and said, would you kindly get over here immediately? So she did finally show up in court, and she apologized to the other litigant. And I think apologies at that point don't cut it. The case should have been handed over to the litigant in the first place. He finally had to go to the Supreme Court. And by the way, he won as a pro se litigant in the Supreme Court. So he probably didn't read any of these unwritten rules, because if somebody told him he couldn't, I told him he could. And not only did I tell him that he could, he did. And he did his own oral arguments. You said that they can't have oral arguments. This litigant had oral arguments before the Iowa Supreme Court.
Yeah, I did before the Iowa Court of Appeals about 10 years
did
ago,
you?
too.
Okay.
Yeah, luckily.
Yeah. But I think the winds of change though are coming about and matching some of these rules that you're presenting to us.
And I think
Go ahead.
the first one that you stated, I think we should summarize that one as the right to jury trial has basically been abolished.
Correct.
You know, when they can just submit their instructions in lieu of the law.
Yeah.
And then on top of that, we've got a lot of courts that just basically overturn a jury verdict.
Well, they've
Very
learned,
loosely
they've learned
sometimes.
how to write the jury instructions sufficiently so that the jury can be misled as to what the law says.
Yeah.
Now, my problem with that is, if we are to obey the law, shouldn't we have an opportunity to read it?
Yeah.
And should a juror have any lesser an opportunity to read the law than a citizen? Now, a citizen, in order to obey the law, should have the opportunity to read it. But anybody who is looking over his behavior and trying to recount what it is that he did that was in violation of the law, that person should have the freedom and should be compelled to interpret the law for what it says, not for what the prosecutor believes should be put in some kind of a formula, just saying if this and this and this and this occur, you must find this person guilty.
Yeah. Don't you just love that, where you read the law and then you read what they interpret the law to be,
Yeah.
And you're like, what? How did you get this from
Right.
that? Why don't you? They should just make a copy of the law book and say, this is the law that he's accused of violating. Here, bam. That's a simple way to do it. It's not being done, and that's why we have so much problems in the court. One of the reasons.
Oh, I like that idea of copying right out of the law book what the Iowa Code says.
Yeah.
The Iowa Attorney General will do that. 15 years ago, he did it on my case. Let's see, John Parmeter by name. Although he's no longer there, I think he got paid more in a private insurance company to rip off people over there. But anyway, I subpoenaed worker under him.
He went to the rip-off division of the insurance company?
I didn't see the actual title.
Okay.
I just heard that he went to the insurance company
Okay.
for business. Anyway, so I went in to subpoena a worker that was under him and another assistant to come to testify in court proceedings. And he said, oh, I'll have her ask for payment in advance. And I said, that's double dipping. You can't do that. She can't be on the clock being paid by the taxpayers of the state of Iowa and then turn around and bill the person that subpoenaed her. And, he said, just a minute. And he ran a copy off the Iowa Code and handed it to me, highlighted. It says right in there, for anybody that wants to know, it's, as far as I know, it hasn't been changed, that anybody that receives a subpoena can demand payment for travel costs prior to going to court. Prior to. And lo and behold, she filed a motion to quash after she received a subpoena. I did get her served later because she wasn't there the first time. And she didn't even show up for court. And the judge quashed it. But then there was another social worker that was served with a subpoena. She never showed up to court. And for some reason, that ticked the judge off to no end. And he turned to the county attorney and said, she's going to be here next Monday. Do you understand? Telling the court appointed, or telling the county attorney that. Well, anyway, 2 weeks after the hearing, I did a little more research into the Iowa Code, and a few paragraphs down, not too many further. I guess I didn't do my legal work good enough. I'm not an attorney, but I'm still trying to learn. And I told you that he highlighted where you have to pay in advance if the party requests it. But there is a paragraph below that that says any state worker cannot collect money in advance. So she lied. She lied to the judge. She lied to me. She won the case. I'll slip the name out. Her name is Wickman. John has been referring to her. She's very important. She handles a lot of cases and lies to the courts. The Bar Association says, oh, she just made a mistake. Yeah, she apologized and changed the things after she realized that she'd made a mistake. Well, it's been since 1990 when she made that lie. And there's nothing been changed, even though she says publicly she's corrected her lie. Well, anyway, I just aired that. If she wants to, Wickman wants to challenge that on the air here, let her go ahead because it's in writing what she did. And the state's Bar Association is letting her go.
So we chalk this up to another unwritten rule of civil procedure. If you're with the state or in the court, you can get away with lying with
anything.
impunity.
Yeah.
I think number 5 on here. Well, we've already named 3 other ones, so this would probably be number 7. The American dream. This has been abolished. The right to own property has been abolished because the courts can be used to seize your property via judicial decisions. When a judicial decision goes against you, the judge has seized your property. Or he can create a judgment lien and attach it to your home. Your right to own property no longer exists. There is no way to recover your home once a judge creates a judgment lien because number 1 through 4 above. Your home will then be foreclosed upon and sold at auction. This is the ultimate outcome of 1 through 4. I am at this level now. I will soon lose my home and all my equity. And this is from Lawrence A.G., who is with the Judicial Accountability Initiative law group. And I would like to also add that you can also lose your kids and lose your freedom. So all the hoopla that was generated by the founders about life, liberty, and pursuit of happiness and property and all that is basically been abolished. That's exactly what he's coming to this conclusion on. And the summary here: the judicial system is like a video game played by judges. Level 5 is the seizing of property. Our property is taken from us and given to the favorite charities of the judges. A few lawyers are speaking out about this system. They are eventually disbarred, though. The judges who speak out are removed from the bench. The politicians all look the other way. They don't care because they are all mostly lawyers who profit from the system. So that's what we got here. Isn't that interesting?
So
I thought that was simple, concise.
Maybe they do that to make us laugh. Got to have some enjoyment in life.
Yeah, I thought this was a simple, concise summary of what really goes on with the courts and the unwritten rules that you don't hear about. And the legal system acts like it doesn't, they don't exist.
that's right.
And, you know, and you get to, a lot of times you'll hear one of the elite legal minds speaking forth in a commentary on a show or in a newspaper about how the judicial system is this or the judicial system is that, or someone that was just wronged by the system. Oh, he was just, it was just a case where he just happened to not win the case or something to that effect. And a lot of times you don't hear about what really goes on with the unwritten rules. If these came to light, then these elites that have a lot to say on all these shows, they wouldn't have a leg to stand on because these things go on. But did you have any other commentary? I think that's about it for me.
There are a number of things in the juvenile court that are distinctively sad, distinctively wrong. For an example, they have what I would regard as the ratchet approach. In other words, once we've made our decision about whether a child is a child in need of assistance or not, that can never be challenged thereafter. So you may, for one reason or another, be talked into signing a China petition in order to get some help for your child. Then you find out that what you did is you simply gave your child over to the district court. The district court, to the juvenile court. And now the juvenile court is your child's new parent. Now the juvenile court can give, maybe allow 15 minutes to review some things that are happening with your child from time to time, because sure, they want to keep control, but you cannot go back and say, hey, look, you used some invalid data or testimony from a social worker, or you didn't give me an opportunity to have my day in court on the child abuse report that was written up against me. The court failed to give me my day in court to challenge the child abuse before the legal authorities there, the ALJ, the administrative law judge. And until we got a recent decision from the Supreme Court, they were actually denying review of the child abuse report because they'd already made a decision in juvenile court. And the juvenile court based this decision on the report, and the report based its decision on the decision of the juvenile court. So both of them can be dead wrong, but because they can point to the other decision made, they can rest on that particular decision, and you can never bring it up again until you go to the Court of Appeals or the Iowa Supreme Court. By the way, all cases are filed with the Iowa Supreme Court, and they decide which ones they'll weed out. The ones they weed out go to the Court of Appeals. And there's actually 3 courts of appeal, so they can handle a few more cases. The Supreme Court doesn't want to handle many cases. They want to handle cases that have broad implications. They don't want to mess around with other cases. Well, we're coming very close to the new year. We're coming close to the time in which the Iowa General Assembly will be meeting in session. I believe that's on the 9th day of January. They'll be getting together to determine how they're going to spend all kinds of money. One of the rules that I mentioned early on was if you have a difficult public policy problem, the solution has been up till now, throw money at it. We have a senator who is in a leadership position now, Mary Lundy from West Des Moines, who says that there have been a lot of promises thrown around at this last election when they elected new state senators and representatives. About $1 billion was promised to Iowa citizens. $1 billion, she says, that they do not have. So a lot of the promises are going to go without any kind of backup or any kind of funding. Isn't that interesting? Everybody has their hand out, and it looks like we've got new money, and the problem is when you have new money like that, I think they're getting $300 million or something from, and they're going to be raising cigarette tax, and they're going to be raising this tax and that tax. They're going to do all this without raising any taxes, except other people's taxes. And of course, the very best tax that you can possibly find is a tax that somebody else has to pay, like the cigarette tax. If you don't smoke, then you won't be affected by those kinds of taxes. But I think that we should be very careful about taxing other folks. Well, one of the things that's going to cost them big, big, big dollars is something called PCA. That's Prevent Child Abuse. Now, for years and years and years, they said the best way to handle child abuse policy cases is to put out money for programs to prevent child abuse. So we've put out millions and millions and millions of dollars to prevent child abuse. And what has happened? Well, the number of cases of child abuse has only risen. So, and I kind of wonder, has it really risen, or has the money that has been produced caused more and more reporting? Well, of course, nobody really is going to own up to what these problems are. But there is an organization called Prevent Child Abuse Iowa, PCA Iowa, that is only too happy to get in on any kind of a program that generates all kinds of money that can be thrown out to the public in general. And every time you throw out a grant to a county or to an agency, a temporary agency out there in government, you also build up a lobbying interest. So that lobbying interest can come back and say, well, in order that we do better and better work for children, in order that we do all these marvelous things around the state, we need more and more money. Right now, they're getting $1.2 million from state treasury, and we have zero reporting of anything that demonstrates that one child was not abused as a result of an of a prevention program that says we are preventing child abuse. In fact, they recognize that 15,000 cases are adjudged to be true and accurate child abuse cases in the state of Iowa, more than at any other time in the history of Iowa. Let me show you a little bit about the kinds of money that they're spending across Iowa from the reports given by this agency called PCA. They're saying that if we have, for an example, if we have something like a child nursery, or crisis nursery, where we can take children when there's a problem, well, 204 families were served by that in this report period for $106,100. Now, if you look at that, that means that we put into the hands of parents who asked for this particular service $510. Parent education used to be, for a few centuries, we were able to parent our offspring without parent education. You did it by grandmothers and grandfathers handing that information down. In the Afro-American culture, that is seen probably the most poignantly, where grandmas and aunts and so forth make certain that these young daughters know how to care for their children. It's seen in other cultures as well, but I've seen it in the black culture tremendously. Well, here parents were served 3,390 of them, but at a cost of $127 a crack. Okay, respite care means if you get tired of your kids, you can call in babysitters to watch over your kids, and they call it respite care. 1,315 families were served at this, but in order that someone babysits your kids, it costs $132.52 per family on the average. Sexual abuse prevention programs. Did it ever prevent one incident of sexual abuse? It may have prompted kids to talk about sexual abuse and so forth. 4,585 families were served by that, and it cost for that large-scale program $33.43. Well, those are some of the kinds of things that we have been talking about. Can you bring us up some telephone numbers? But the bottom line is we're going to be spending a lot of money in this next legislative session, and you need to be talking to your legislators. Here's phone numbers that may be of help to you. We'll see you next week.